All right, my friend, Mr. Steven, I believe we are live now, and it's been a while since we did one of these together. How you been doing, man?
Man, I'm doing good. I know you played hooky last time around, and you had to subject me to co-hosting with Mike Cardoza. And
Yeah, the wild man Cardoza himself.
I had a detox after that, man. That was a wild ride doing any sort of a live show with Mike. But no, I love Mike. He's awesome. But no, man, it's good to see you here. I was out of town for a week, back in here, and glad to be doing legalese again with you. It looks like we've got a lot of cool things to talk about. We've got attorneys suing the bureaus for 609. That's always a pleasure. We've got courts making rulings that credit bureaus are not obligated to resolve or arbitrate or get in the middle of not mine type legal issues. And you've got some FDCPA stuff. So, man, we've just got a full plate today. And for those of you guys watching live, obviously, post up your comments down below wherever in the world you are, so we can go ahead and interact here, man. So, John, how are things in your world, brother?
It is probably been the busiest time that I can remember. We've just been absolutely slammed in pre-trials, which is where we go in front of the judge and talk about jury charges and how long the trial is going to last. And then
that's when you go before the judge with the big briefcase for his re-election campaign, and you're like, Judge, just by the way, I know you're a state judge, right? So you get elected every 2 years. Just want to give that to you. And oh, by the way, here's what I really want to talk to you about. Is that what you're saying, John, or it doesn't really work that way?
No, it doesn't work that way. It doesn't work that way. We come with iPads and no briefcases anymor. But
you transfer the cryptocurrency. It can't be tracked. I hear what you're saying, man. So anyway, Go ahead, man. We're being silly here. So go ahead.
So we've been doing that, and mediations where we try and settle cases, and arbitrations where you don't have a judge, you have an arbitrator who decides for you. And so we're hiring new people, and it's just been kind of a wild ride. And now I understand that you flew a little bit south here for the last week or so. Is that right?
We did. I've been in Mexico for a week and went up all the way to the top of the mountains. Beautiful, clean air. You can see the stars. Then I went to Mexico City where the air wasn't clean and you couldn't see any stars. But I had this awesome Airbnb condo in the middle of downtown Mexico City, which was pretty cool. So, yeah, a little vacation away, and we are back in town here, though, man, rocking and rolling. So,
well, good. Well, I tell you what, before we chat about a couple of maybe legal things, why don't you give everybody an update on your software that
absolutely.
I guess we'd say it's primarily for credit repair companies and lawyers that do credit repair. And so what's the latest word on that?
Yeah, absolutely. So we launched our beta at CreditCon, Palmieri System. You can go to palmierisystemdemo.com, and I've got a cool little 2-minute video. And if you like what you see, push the little call to actions, and you can sign up. We do give you a free trial, but it's the first software in the marketplace. Well, it's a simple application. It's not a CRM. It's not a freaking client manager. It's not a portal. It's really designed to do one thing really good, which is let you do really good factual and Metro 2 factual letters. You can put the data from all 3 bureaus automatically in one letter if you want to, and you can send the same letter to all bureaus and the furnisher. Nothing better than checkmating them with their own data, and it does allow you to actually dispute based on Metro 2, so which is their own industry standard. So yeah, Palmieri System Demo. We've still got a few slots left for our beta release. And so we'd love to chat with anybody who's interested in being able to more easily automate the creation of those factual and Metro 2 factual and Metro 2 letters. So,
well, very good. Very good. Well, keep us posted. And of course, you know what I'm always hounding you about with text messages and other things is, when we can pull in.
I'm going to tell you, so John Watts is always beating me up because he wants me to be able to pull in that annual credit report data, which we will get there. But I'll tell you, John, like my development team always tells me, they're like, Steven, there's this triangle of software. I can't even do a triangle with my screen here. It's all backwards. There's this triangle, right? It's like that's that high up triangle. There's a triangle of software development: time, money, and resources. And they're like, you can't have all 3 of those at the same time. and stuff like that. So time, money, and resources. So we will get you that annual credit report scraping at some point in time, which is going to be pretty amazing. But you've got some other things kind of in the development pipeline. But right now we will pull Smart Credit, Identity IQ, and My Score IQ. So you can work with those reports as it is right now.
Okay. Well, very good. Very good. And just a reminder to everybody that is online, feel free to type in questions and we'll be glad to answer those. Stephen, I'd mentioned this to you right before we got started. I had an interesting, relatively small case, but I thought it was an intriguing argument made by the debt collector. So this is the setup. So client sends a letter to the debt collector saying, I dispute this debt and I refuse to pay. And so the collector responds back and says, hey, I got your FCRA dispute and we deem it to be no merit, so we're not going to investigate it. And here's what you owe, and this is an attempt to collect a debt. And then it had page after page after page of contract and invoices and all that stuff. So I sued them for violating the refuse to pay or cease.
Hold on a second. So this is a John Watts firsthand information story. This is not like somebody else. This is John Watts making case law. I'm assuming.
Yeah. So I don't usually talk about my own cases that much, but
that's a problem. You need to be talking more about your cases. Man, we need to get you like way high up there in the case law case maker guy. Okay, so you sue them because they sent a cease and desist. It was one of those combo hybrids. Hey, I'm not really sure what you're talking about. Oh, and by the way, I refuse to pay you. So it's kind of like a dispute / cease and desist.
So it really wasn't sent under the FCRA, but it was interesting because they took the position that this was sent under the FCRA. So here's the significance. We sued under 1692 CC, which is if I tell a debt collector I refuse to pay, then they can't contact me. Well, they did contact me and they sent all these papers. And so we sued them and they said, well, we didn't respond to you under the FDCPA. We responded to you under the FCRA. And this was a direct dispute. So not through a credit bureau, but directly to the collector. And therefore, we're exempt from the cease and desist or refuse to pay. And so my response was, well, you might have an argument if you didn't include multiple pages of invoices and documents, which are obviously designed to get us to pay. And ultimately the case settled. But I thought it was an interesting argument. So just be aware for, folks doing this on their own or, credit repair companies that are sending refuse to pay or cease and desist letters. If you put the word dispute in there, while I think it's a lousy argument, you may have a debt collector say, oh, well, we thought since you said dispute that you wanted us to respond to you under the FCRA. And
so let me ask you kind of a question here. So let's say you got these ambiguous, vague, well, I guess John Watts never has anything that's ambiguous or vague before he sues, but let's say a consumer, you want it all to be ambiguous and vague, right, in your favor. So let's say a consumer disputes a bunch of stuff and they don't really know the laws and they send something to a debt collector, which really could be interpreted properly as an FCRA or an FDCPA or maybe even a state law dispute. I mean, obviously, under the FCRA, the consumer can't privately enforce, can't sue the furnisher for furnisher direct disputes. But if you dispute through the bureaus, then you can sue the furnishers, if you can hold that they're liable. But will you say in your pleadings, the consumer disputed, under the FDCPA or as an alternative, it was under the state law or the FCRA, will you try to throw one dispute and tie it to multiple potential causes of action if you don't really know where it is? Or do you want that thing to be judge, this is very clearly an FCRA dispute or an FDCPA, and that's all we're arguing in it?
Yeah, we try to make it very clear. And in this context, again, if the debt collector had just responded under the FCRA, then they might have had an argument. I don't think they really did. And I won't go into all the details. There's an FTC opinion from 1998 that they were trying to rely on. But the point is you just have to really understand these laws, to be able to anticipate what they're going to do. And then when they come up with these crazy arguments, to be able to say, okay, well, here's the counter to that. And so, again, just have to be careful. And I see we have some questions here. We'll get to those in just one second. But, there's a recent Seventh Circuit case, and I've been off Facebook, so I'm not sure if it's been posted in the group, from, like I said, Seventh Circuit Court of Appeals, where they ruled against consumers. And this is something you and I have talked about, Stephen, this sort of legal dispute. So if you go to a credit bureau and you ask them to decide an issue that is not factual, but instead is legal, and that's a very hard thing to distinguish, okay, sort of in the eye of the beholder. And if a court has not decided it, then a lot of times the federal courts will say the bureaus don't have to decide legal disputes. So somebody sued the bureaus and said, hey, I don't think LVNV or Portfolio Recovery or Midland Funding or whoever really owns this debt, and so get rid of it. And the court said, well, no judge has decided or ruled in your favor, so we're not going to make the credit bureaus, be liable for this. Now, the solution is what, we've been preaching for many years, which is go win the case. So if Midland sues you, win that case in state court. Now you have a judgment. And then when the credit bureaus ignore that judgment, now we expose them as hypocrites, because they go around the country saying, oh, we can't possibly decide legal disputes. We need a judge to. Well, we have a judge's order, and they still ignore it. And then, it leaves them a little bit speechless. And then they start saying, you'll appreciate this, Stephen. They go, well, we don't know what it means that you won the collection lawsuit. I mean, we don't know. What is judgment for defendant? And you're the defendant. What does that mean? We don't know. Like, we're complete morons at the bureaus. I mean, that's their argument. So it's a very strange position.
Yeah, because the judgment for defendant didn't say, debt not mine, never late. So let's talk about that though real quick. Actually, I think it's really important, right? I mean, because the FCRA has a couple of different provisions in it for what you're trying to complain about. So you've got the 1681I standard dispute, where you can dispute the completeness or accuracy of an item of information. But then you have the identity theft provisions, where if you're like saying this literally is not mine, well, it's either going to be a mixed file, mismerged file, or fraud. Like, that's pretty much the only real reason why it's not yours. But then there is the typical credit repair type, not mine, which is, well, it's just they've not really verified it, So I think it's that last option there. It's kind of what you're saying. The courts have ruled, well, if it's not really yours, it's either mismerged or mixed, which means the bureaus are going to get sued anyway because it's really not yours. Or you're supposed to go ahead and get a police report, an affidavit, all this stuff, and send it to them, and then they're supposed to figure it out. But if you don't do any of that, and it really kind of is yours, it's just you're upset because nobody has a contract, which is valid for you to be upset because of that. But it's not the credit bureau's problem to like say, well, there is currently no contract, so it's not a valid debt, right? So, I mean, I think that's kind of what you're saying is what the court cases are, is if you're basically saying not mine with no substantiation behind it, the bureaus are under no duty to delete it just because they go to the furnisher and the furnisher's like, yeah, we got nothing, but it's still accurate, so we're going to keep it. Is that kind of what you're saying there?
Yeah, and it's, look, here's the confusing part. If you read the FCRA, it says delete stuff that is inaccurate or incomplete or that cannot be verified. And so you think, okay, well, if I go to the credit bureaus and say, hey, go ask Midland Funding or Portfolio or LVNV to give the purchase agreement. Well, they can't. So it seems like it's unverifiable. But this is where you have to read the case law, not just the statute. That ship sailed a long time ago.
Well, and that would be, yeah, I mean, because they are verifying the data with the furnisher. That would really more be a data furnisher argument. The data furnisher verified it to the bureaus, but the data furnisher really had no basis if they literally had no contracts, no nothing. I mean, but then again, if you're only still saying, because if you're only still saying, well, they're not legally obligated to it, the furnisher can say, yeah, it is. But if you're saying a whole bunch of stuff like maybe your prior payment history is inaccurate and they don't have any documents. I mean, now you have some sort of factual and Metro 2 factual type issues to say, well, how could you, furnisher, have verified this when you literally can't produce any sort of original records to validate the payment history? But I mean, to your point, the bureaus absolutely did verify it with the furnisher. Whether the furnisher's verification was proper or not is a whole other thing. But whether it's a matter of law issue or an FCRA credit issue, that argument, I think the takeaway is between the consumer and the furnisher or the creditor, not really the bureau.
And this idea of, okay, Midland doesn't own this debt, LVMV doesn't own this debt. And look, I've been filing those lawsuits for 15 years, so I'm
Dude,
pretty
that's how we're able to buy those nice shirts and stuff you got, man. Is that MCM? Is that MCM emblazoned right here, Midland Credit Management?
Probably not. But you need a judge to rule in your favor or make it factual. I mean, we have to be fair to the bureaus, even though they're never fair to us. We have to be fair to them. Either give them information that they can see this is inaccurate, or hey, here's a judge's order, or don't sue them. So like the classic is, hey, I called Discover and Susie on the phone told me I could skip this month's payment. They wouldn't report me as late. Well, how's Equifax supposed to know that? You make that dispute, but don't sue Equifax. I mean, there's plenty Equifax, Experian, TransUnion dude that they deserve to be sued, and they should be sued often and repeatedly. Okay, but we have to follow the law.
See, John, that's why you need to stick to being an attorney and not an expert witness. Because if you go out in public with an attitude like that, there ain't nobody that can say you're an impartial arbiter of expertness.
Oh yeah.
You need to stay the guy that can sign the lawsuit.
Yeah, I've never claimed to be impartial. Matter of fact, I'll put up this link here. This is we're starting.
That's why I love doing this show, and then I love doing the expert witness show with Doug Miner, because they're two totally different animals. I mean, I like to kind of poke at Doug a little bit, but he stays so calm and cool. Like I try to get him, but he's got to stay, kind of like, he can't say things that you and I know he wants to say, because he's an expert, whereas you're
this link I put up is for anybody who's interested in our daily ranting emails about all these credit bureaus and debt collectors. So yeah, I make no show of being neutral. So well, let's see what we got here. So we got Fern Money. Welcome back, guys. Recently received a response from Equifax, states account was updated, yet the account is still reporting inaccurate payment history. So what would be your advice for Fern Money on that, Stephen?
Well, we'll sue the bastards. I mean, that's going to be my answer from the John Wise perspective. But I guess really it kind of comes out to, number one, what did your dispute itself say, right? So, I mean, did you really put them on notice of, did you just say, please verify, or did you say, hey, this is wrong with the payment history, and, here's actually what's wrong and why? So let's back up for a second. So how are you saying the payment history is wrong? Are you saying that, because you mentioned Equifax, is it inconsistent among the three bureaus? Is it 30 days late this month in Equifax with 60 in other? Or is it there's just missing payments, which, by the way, the Equifax paper reports never give you positive payment history, which is interesting, right, John? Because literally you look at an Equifax paper report and it only gives you the 1, 2, 3, 4, 5, 6 L's, right? Which is the delinquencies, but it never gives you a positive payment. So, I mean, every Equifax trade line is going to have an inaccurate, on the paper reports, is going to give you an inaccurate payment history because they don't give you the positive. So, I mean, I guess my question is, what did you dispute and what really is inaccurate with it? If you want to kind of comment that up, we could probably take another stab at it. What are your thoughts, John?
Yeah, I mean, that's I have a very sort of strict way of disputing. I don't want to dispute stuff and just say, well, this is inaccurate, verify it. To me, that's worthless. We've got to be very specific. So, like you said, Stephen, if we say the payment history is inaccurate, well, how's it inaccurate? I want the judge to read the letter, the dispute letter, and look at it and go to Equifax, well, that's pretty clear. What's the answer? and then watch them sputter and make excuses. So we have to be very, very specific about it and have the proof. So if we say, I wasn't 60 days late in June, well, what's our proof of that? Now, it might be in May, it says I was current. Kind of hard to be 60 days late in June if you're current in May. Or maybe you paid it off in May, and then in June it says you're late. Kind of hard to be late if it's paid off. But other times you may need to provide proof that, well, here's where I did pay it. Or look, here's TransUnion, Equifax, Experian, they contradict each other. So we just have to be very specific about it.
That's the Palmieri system way right there. You just put a copy of that credit report in there, and you put them on notice of everybody's reporting. You know, it's kind of like you kill them all and let guys sort it out, like the Marines say. You know, it's like you guys have one standard, but it's 3 bureau reports. You guys just all figure it out, man. I'm not even concerned, right? And when they can't figure it out, I got John Watts over here. You know, he's just itching on the trigger finger. So, all right. So
yeah, and let's see. Somebody asked how to get some stuff over to me. So just email is fine. And let's see, here's Fern. Did negligence, non-compliance considered taking action? Yeah, so Fern, it's really going to be, you know, what is it that you notified the bureaus of very specifically that is actually incorrect or incomplete, and then what did they do? Let's see.
Hold on a second. No, go back there real quick. Any suggestions? Yeah, Fern. I wouldn't do that yourself, pro se. So I'll get you a good lawyer. Wait, I see. I just hold backwards. Crap, man. Get you a good lawyer right there. We go. Get you a good lawyer right there. And if it's a good case, you'll be in much better position with him. That's my suggestion to you.
Yeah, and I will say this, and you know, it sounds self-serving, but if you have
but you know what? You deserve to be self-serving, because if you can't serve yourself, who else is going to serve you, right?
Yeah. But if you have a legitimate case, you're going to make a whole lot more money having a lawyer, unless the lawyer's ripping you off. You're going to make more money having a lawyer that knows what he or she is doing than trying to do it on your own. And, you know, it's sort of like a lot of these statutes have fee shifting where you can recover attorney's fees. And if you go in without a lawyer, it's sort of like saying, I'm going to go to the Super Bowl and I'm not going to make any passes. I'm just going to run the ball. Well, you could do that, but you're giving up a lot of your options there, which is just not, in my view, not particularly smart. Let's see. Rick says, Navy federal account listing on my credit reports paid in full, but shows 2 late payments and no account number. Very strange. And then, let's see, is that legal? Appreciate the info. And Equifax says account is indisputable because of no account number to dispute. Okay, that's interesting, Rick. So let's go back here to this first part. It's paid in full. Okay, so that's great. It means you paid it off, but it shows 2 late payments. So here's where we need to know, Rick, when are the late payments? Did the late payments come after it was paid in full, or do they come before then? So if you paid it in full in April of this year, are you saying there's a late payment in May and June? Well, that's a big problem for Equifax and Navy Federal. But if it's from a year ago, well, then the question is that truthful? Were you really late a year ago? And this idea of Equifax saying you can't dispute because of no account number, I honestly have never heard that before.
Dude, if I were you, I'd be like, dude, John, that's like Rick dude, just like make the beeline over to John's portal and like give him that freaking thing. He's like, dude, they basically de facto admitted that their stuff was so incomplete. We can't even figure out how to reinvestigate it because they gave you subjective information there, man.
Yeah, that's really crazy. So
make sure you go out, Rick, and get damaged a little bit more than you're already damaged, to just juice it up a little bit more.
Well,
to give them another opportunity to do you right. And if they don't do you right, then you're going to be hurting more. And then John Watts is on the case.
Yeah, and in all seriousness, you know, sometimes the account numbers are incomplete. You know, Equifax might give you the first few numbers, and Experian might give you the last few numbers, and you're trying to match them up. What I suggest is just describe the account as best you can. Like the one way I like to do is say, I'm disputing my Bank of America account that was opened on May 23rd, 2006, and it's an individual credit card account. Well, then if Equifax says, well, we can't find it because you don't have an account number, and we're just complete morons and have no ability to actually look at your credit report, well, then, pay the price for that, Equifax. But so just describe it. You might say it's reporting with a balance of $5,043, or you're showing me late in June and May of 2021. Just, again, kind of think about, if you're in front of a judge and a judge is looking at that letter, would the judge say, yeah, you described that very well? Or do you go, I've got some kind of credit card, and Rick, I know you didn't do this, but I've got some kind of credit card that I think is wrong. Investigate. Well, that doesn't mean anything. So describe it in some way, and then you'll be in good shape. But I would love to see Equifax's response to you, Rick, where they say, because there's no account number, we can't investigate this. That's pretty wild. So
yeah, we've got actually a good question from Shar in the Facebook group. She's asking, what type of report did you pull? Because if you pull the monitoring reports,
okay.
sometimes those are kind of garbage. Well, versus was it the actual Equifax paper report? And something I'll add in also is, when you disputed it, did you send them a copy of the credit report image? You can actually paste or drag and drop a JPEG image into a Word document. So what we do with all of our disputes is, in addition to typing the data or using our software to manually automatically put it in, but you put the data in the letter and then you put an image of the credit report. Because we all know that what's in their computers is going to be different than what's on the paper reports. So I would definitely send them a copy of the page with the trade line. And if it's not the direct Equifax report, send that to them as well.
Yeah, that certainly can help to attach it. So definitely a good idea, or drop it in. So let's see, Spidey time. Midland summons me to court in July. The continuation is in September. Okay, so I guess you get sued in July. Maybe there was a trial date, but it's been continued to September. Statute of limitations expires in August. Can they still sue me? So it's a great question, and I'll take sort of first stab at it. Statute of limitations is the time period to sue you. And all that matters is the day that they filed the lawsuit. It doesn't matter when you're served. It doesn't matter when you go to trial. The only date we look at is the date of the lawsuit. So let's say statute of limitations expires August 1st. They sued you on July 1st. Well, then they're good because they sued you before. I mean, I've had cases, this is unusual, but I had somebody one time, they were sued by LVNV and they were served 5 years later. Well, that's a little extreme, but it doesn't change the fact that, all that matters is, did they sue you before the statute of limitations?
But we're no longer even interested in the credit. Let's talk about that. For how in the world does somebody get served 5 years later after the suit is filed?
Yeah, a very generous judge. So most states say that if you don't serve somebody in about 120 days, the case will be dismissed. But some judges are very lax about that, or the creditor or debt buyer will say, hey, give us more time. And they just continue to give more time. And but that's very unusual.
Well, but I mean, like in this case was like, what's this story here? I mean, were they like, judge, I mean, this consumer literally, like, we literally couldn't find them and we sent the skip tracer out for 5 years in a row, we can prove it? Or like, was this thing just jammed up under somebody's desk for 5 years and then they were like, oh, judge, I mean, can you hook a brother
up? Yeah,
the
person was living in the same house all these years, hadn't moved, and it just had never been served. And I think the judge sort of regretted it, but the consumer won, so it didn't particularly matter. But the point is, just think in terms of a timeline. It's the date suits filed. When you go to trial doesn't matter, because a lot of times, let's take a personal injury context. We might file a suit, a week before the statute of limitations expires on a car wreck case. Well, the defendant's not going to be served for maybe a month or two, and then they have a month to answer, and then we might go through a year of litigation, then we try the case. So most trials happen after the statute of limitation, but it doesn't matter because all that matters is when did you file the suit. So, you're pretty close. If the limitations expires in August, you were sued in July, you may want to look at that very closely and see if it really expired in July before you were sued. But
let's talk
again,
about
it's the date
something.
sued.
Let's talk about something real quick. I think our audience would find informative about being able to counterclaim for time-barred claims as a counterclaim to a lawsuit, right? You could probably say it a whole lot better than I could even begin to. But basically, like if you were to file a lawsuit, like let's say on something with let's just say an 8-year statute, I'm just pulling numbers out. If you sue them for something with an 8-year statute, then they can counterclaim you for something that would have only had maybe a 4-year statute and was already expired. Can you know what I'm trying to say? Can you kind of articulate that better than the non-attorney over here to our audience?
So if you're sued, you can bring a counterclaim where you sue back. And even though your counterclaim may be beyond the statute of limitations, there's two basic ways to do this. One, you can sue and basically all you can do is offset the claim. So let's use an example. LVNV sues me for $10,000 and I want to sue them under the FDCPA, but the statute has expired because it's only a 1-year statute of limitation. And say they broke the law 3 years ago against me. Well, I could counterclaim, but some states would say I can only get up to $10,000, the amount that LVNV is suing me for. Other states say, nope, if somebody sues you, boom, you can counterclaim, and there's no limit to the amount that you can counterclaim. So, yeah, sometimes, you may lose a claim, but then the bad guys sue you, and that opens the door to be able to counterclaim against them. And one interesting thing about counterclaims is, so let's say in the context of consumer law, LVNV sues you, you counterclaim, that case is not removable. They cannot take it to federal court because they're the plaintiff. And so they're stuck in state court, which most debt collectors do not want to be when they're sued.
But that's assuming they sue the consumer in state court.
Yeah, if they sue you, yeah. And they always sue in state court. So
yeah, so they like to play the game too. They like to force the consumer to have to get it removed. Well, I mean, I guess why would you even want to get it removed to federal court if you're the consumer? Wouldn't state court be a more friendly?
Yeah, and typically as the consumer, if you're sued in your own state, you can't remove it. Okay. So the reason these debt collectors can remove things when we sue them is it's a federal claim, so they can open the doors to the federal courthouse. But the point being that, there's just a lot of strategy in this. You get sued, you counterclaim. Now, personally, I don't like to counterclaim. I'd rather just beat them and then go file a separate lawsuit. But I'll give you an example. So in Alabama, if I'm sued by Midland Funding and I answer, and if it's under $20,000, I'm generally going to trial in 4 weeks. Okay. You take Mike Cardoza in California, same lawsuit, he's going to trial in 18 months. Now, which is better? Well, it's not that one's better or worse. It's just they're different. So if you have a really long period of time, you may need to counterclaim because you might lose your statute of limitations for filing an FDCPA case. I don't really worry about that because we get to trial so quick that it's not a concern for me. So you have to know your own state and think through all the strategy of this.
So when you say you sue them and you beat them, but then you'd like to file a separate lawsuit, usually when you have, I guess unless it's a judgment, but if you're settling them, wouldn't the settlement agreement have some sort of language where your client agrees not to sue them for anything else, any other claims? So how do you work that little detail out?
Yeah, if you settle with them, so take a Midland Funding sues us. If we settle, then part of the agreement is going to be we don't sue Midland. But let's say we go to trial and we beat Midland. Well, now it's fair game to sue Midland.
Gotcha. So when you say beat, you really mean beat, not settle.
Yeah, or even if we settle and let's say the case is dismissed with prejudice, well, we can't sue them for anything in the past, but 6 weeks from now they update our credit report. Well, we can always dispute our credit report, and that's a new cause of action that we could sue the bureaus or sue Midland for. So there are many paths to get to where you want to go. So let's see here. We got
good stuff.
Somebody's saying, let the beatings begin. And let's see here. We got somebody doing like some kind of shameless advertising for some Palmieri guy.
That's Shar or Michelle or somebody.
Yeah, that's how do I get that off the screen?
You can't. It's like a virus. It's going to be permanently right there.
Yeah, we're just gonna like have across the top sponsored by the Palmieri System
PalmieriSystemDemo.com. PalmieriSystemDemo.com. Go there. Get your
I think I like
the software.
Just to show you what a good guy I am. I think look at this.
Boom! There you go, man. That's right.
I don't know why it's not popping up on the other ones, but anyway. All right, let's get back to this now. Okay, here's Fern. I dispute the payment history. Example, in June, it was 30 days late. Then the next month, it shows 120 days late. How is that possible? Sorry, we can only type few character. Yeah, that's a good description. So
Fern, that should be your dispute letter literally right there. Take this right here along with a copy of the credit report image, preferably the one directly from Equifax. But if you have to, use a monitoring, but get the one directly from Equifax. Literally just take this exactly right here minus the last sentence.
Yeah. And
the question mark.
Now there's always
exclamation point and send it over, certified mail to Experian, Equifax, whoever. And then when they give you the middle finger or the confused emoji or the whatever,
or just ignore it.
Send it over to that guy right there.
Yeah, and I'll say this now: if you really were 120 days late in July, now that's a different matter. It could be that the error was.
See, now you're starting to talk more and more like a defendant's attorney, not a plaintiff's attorney, man.
No, we always have to anticipate this stuff. So, but if you were only 30 days late in June, then yeah, the last time I checked, I mean, I count on my fingers, but I don't think we can get up to 120 from 30.
All right, so then what that means is then you need to send a furnisher dispute to the furnisher and ask them exact same thing. How can it be? And please provide me with original records. And if they don't give you any sort of original records to validate what your payment history was, it gets me every time. Then you go to this guy right there.
You got to reverse your mind. Like, imagine you're teaching a yoga class. You can't say raise your right hand and you got to use your left. Okay.
Just keep both hands moving.
Just have to reverse your mind. So, and look, I'll say this, Fern. I've got a video. I think it's going up tomorrow morning about how the credit bureaus really treat us with contempt. And what I want you to think about is, like, let's say you send that letter and you go, hey, Equifax, I mean, how do I get from 30 days to 120 from June to July? That doesn't make any sense. Well, you would expect that they would show you a little bit of respect and answer you and say, well, dear Fern, here's how we did this, or here's what happened. No, they won't do that because they can't be bothered to spend any time with you. That dispute gets sent overseas. You've got people that usually don't speak English that are looking at your dispute. At least they're not native English speakers. And there's nothing wrong with outsourcing work, but they're outsourcing work not to get the best workers, but to get the absolute cheapest workers, because they don't care about your dispute and they don't care about you. And I mean, we get this from the lawyers. They're very condescending. The corporate representatives of these companies are condescending, and they just view everybody as like, how dare you dispute something? We saw a little bit of that at Credit Con with, one of the industry guys, sort of like,
good old Francis.
Yeah, you credit repair people, and you're like messing things up. And look, if you're disputing stuff that's not actually wrong, then I agree with him.
Yeah, but let's talk about that, because that really epitomizes using their own industry standard, Metro 2, as a basis for accuracy. Because if you send them their own reports and you put in the dispute the data from all of the bureaus where it's reporting, and you're like, I'm confused because you guys have all adopted and conformed to this one format, prove to me that the furnisher did not submit one data batch to all three of you guys at the same time, because that's what they're supposed to do. Capital One types it in and hits submit one time, and the same batch goes to everybody. So I'm confused. So that is really epitomizes being able to checkmate them at their own game. Because if you were to sue these people, and I've been in depositions for my clients that have done this, and I've been a fact witness, and if your dispute letters are teed up and you've got the credit report image in there and you've got the data in there, the only thing you got to say is, well, I mean, that's why we asked you guys. It's your own industry standard. I don't even know what it's supposed to be, but you mean to tell me that it can report 3 ways? You can absolutely checkmate them against each other. It's really the only way that you can really do that without them being able to kind of give you that contempt type thing. Like if you're just doing some sort of a, regular dispute, like, prove it, or you don't have the contract or whatever. But if you can checkmate them against their own industry standard, it's a whole other ballgame. I mean, it's really hard for them to defend that it's reporting literally 3 different ways. Now they may say, well, to use John, I'm Equifax's lawyer. How do you know we were the wrong one? Well, we don't know that you were the wrong one, but you didn't prove that you were the right one either, and you've just been sued. So I guess prove it to the judge.
Somebody's wrong. Yeah. So, and look, we don't mind suing a bunch of people and having them point the fingers and shoot at each other, because then we just sort of step back and we'll just sort of watch this. But look, here's the thing that what we try to help judges understand, and if we're in trial, help jurors understand. You write this dispute letter and you spend time, usually a lot of time writing the dispute letter, very detailed, and you ask questions and they won't even respond to you. I mean, think about if you called the dealership where your car is being worked on. You said, hey, I need to ask you a question about my car. And they said, we will not answer any questions. You call the IRS. I mean, good grief, the IRS will answer your questions. Okay. I mean, every company, every governmental agency almost will answer your questions. And the bureaus are saying, we won't answer your questions. You can write all the letters you want, and you're just getting these forms.
That is just not fair, John G. Watts. I've got to go ahead and tell you, they will absolutely answer your questions. You're just asking them to answer them in the wrong forum. You have to sue them, but then they'll absolutely answer your questions.
Yeah, and then you're
not doing fair with our listeners here.
Yeah, man. Well, we can accommodate them by suing.
Which is really crazy, but that's actually the truth. I mean, it's wild, huh? Isn't that something, man? Imagine if there was no FCRA, huh?
That's right. It'd be, not much hope there. So here's Rick. Rick had the problem of they were reporting late payments after paid in full. Well, I ain't the smartest guy in the world, Rick, but I'm pretty sure if you paid it in full and there were no future or further charges, you can't be late after you paid it in full, So I would like to see that. That would be very interesting.
There you go. And shameless self-promotion right there.
Thank you.
Bring it to Brother Watts.
And then let's see here.
Not your account. Well,
and Rick said, not my account. And then no account number whatsoever. I sent them a copy of the report. Yeah. So it looks like you're in Oklahoma. So Rick, just get with me through alabamaconsumer.com. And there are some lawyers in Oklahoma that we work with. Be glad to help you there. And let's see. So someone, they accidentally misspelled it, Equitrash instead of Equifax.
Michelle Peoples, gotta love it. I'd never seen that one before, Michelle. That's smooth right there. Equitrash.
Always missing account numbers. Yeah.
By the way, Michelle, proper English, you've got to capitalize the letter of Equitrash. That's a proper noun right there. That's their name.
Then somebody says, always add that image to the dispute. So it's a lot easier now, to do that. And, that's certainly something that you can do to make the letter more understandable. Let's see, date on when the summons is filed. Yeah, so it's really when that lawsuit is filed, that's the trigger date that we compare with statute of limitations. And let's see, Fern says, by the way, I sent all my disputes certified mail. Very good. We're very happy to hear that. We returned receipt. So they won't use the line, we didn't receive it. And because, so let me tell you this. There was a guy at CreditCon that got on stage and said, don't waste your money on certified mail. We treat them all the same. And certified mail doesn't do you any good in court. And I'm thinking, I don't know what courts you've been in, but every federal judge I've ever been in, they completely understand certified mail. And the argument was, well, you might send a blank package by certified mail. I have never heard that except from, one speaker. And I've never seen a judge go, well, it's possible they could have just sent a blank envelope. Okay. That doesn't happen in the real world, at least in my world.
And what you can do is put the certified number, if you get you a whole stack of those certified letters with the numbers, put the number on the cover page of the letter, like literally type it on there. If you know which one you're going to be using, like have them on your desk, a whole stack. I guess if you print the postage, maybe you can't get the number in advance, John, but I'm still old school. I've got a big ass stack of those numbers like that I stole from the post office, and it's just every time I do a dispute letter, I just will type the number on it.
Yeah.
So that way it's actually on the letter itself. So that's a way to get around them saying you mailed them a blank envelope.
Yeah, and certifiedmaillabels.com, and I think LetterStream. These are services you can upload a PDF and do it by certified, and you can click a button and they'll print the tracking number on each page, so that can be helpful. But look, this whole thing, we didn't receive it. That's a great argument if it's not done by certified mail. So Fern, you're very smart to do that. Seems like they get mad that we consumers want to clean up. That's right. That's where this sort of contempt and just anger and how dare you challenge us attitude comes out from these bureaus. And so, we know
nothing better than like being in a deposition against a credit bureau and then being able to say, so you make no dispute that it wasn't your bad charged off debt. And then you can just say there and say, no, absolutely not. We make no dispute that this isn't our debt, but we make a dispute that all these entire data fields are jacked up, and you guys are data brokers. And Metro 2 is your data standard, right? Like, again, Metro 2 is the Achilles heel against these people because you can literally tell them, I never disputed that it wasn't my debt. I mean, I don't know if it is or isn't, but that's not the dispute. But the dispute is your data is jacked up. And you guys are data companies, and it's your data standard, and you've got to have the reasonable procedures to conform to your data standard. So, it's really just, there's no shortage of ways where I'm understanding Metro 2 as an industry standard for accuracy, where you're not just challenging whether they certified the reporting, but where you actually can say, hey, this is why it should be reporting accurately. There's almost nothing that they can come back at you, and because you're using their own standard against them. But yeah, that certified letter stuff is good. And so, John, you've never had them say that they mailed a blank envelope, huh?
No. And I can just tell you that all the lawyers I know that do this type of work, and again, I've been going to, national conventions of, those of us that do this type of work since about 2006. And I started suing the bureaus about 2001. I have never heard a lawyer say, you know what, certified mail is not a good idea. Judges don't appreciate, like, those words have never been said. Matter of fact, the case law, you'll see judges write in there and say, if this was really important, talking about maybe it's a mortgage company that claims to have sent something or a business claiming to have sent something, the federal judges will say, if it was really important, why didn't you send it by certified mail? Everybody knows certified mail is the way to go. So this idea that don't send it certified mail.
Well, Judge, because I went to this credit conference in Clearwater, Florida, and there was a speaker guy that said certified wasn't really important in court, and so I just figured it wasn't important. That's not going to fly, is it?
So look, I mean, everybody's entitled to their opinion, and that I just find that to be not a good thing to say if you're interested in being successful in litigation. So here's somebody, when it comes to statute of limitations, a great question. Do you state that you're in or the state of the furnisher? It depends. You first look at the contract, because the contract may say the law of Virginia applies or Delaware, South Dakota. And then you have to dig a little bit deeper to figure out, well, does your state allow that? It gets complicated with things called borrowing statutes. They may say, oh, well, we'll borrow another state if it's a shorter statute of limitation. You have to figure out if your state considers statute of limitation to be what's called procedural or substantive. Okay. So I would check both of them out. And, you obviously use the one that's to your advantage, but just understand it's not a very simple thing. You have to dig a little bit on this. And, you'll see people online saying, oh, well, just say Virginia, and they immediately give up and beg your forgiveness. No, it's in the real world, it's a little more complicated than that. But you're definitely on the right path to at least ask these questions and figure out what the possibilities are. Because a lot of times the credit card company will use a state that is favorable to them, but maybe not on statute of limitations. But think about it this way, credit card companies don't sue you at 5 years. They sue you at like 1 year. So it doesn't matter to them. It's really the debt buyer that is coming along suing later. That's where another state's statute of limitation may be helpful. And let's see here. We've got Rick saying Equifax is famous or maybe infamous for that. Let's see. Speaker Francis was courageous speaking smack about credit repair to a group credit repair. Yeah, I mean, look, give the guy credit. He was very authentic, and I think if we take what he said, and if we're talking about credit repair companies that are doing bogus disputes, then amen. He was right on track. But if he's talking about legitimate disputes when they have errors, then he was way off base. And again, it's sort of this idea like, don't sue us because we're doing a great job. Well, how do you know you're doing a great job? Because I just told you we're doing a great job. Well, that might be a little circular there.
Well, and the issue with that guy, because he's the president of the CDIA, which is the Bureau's trade association that owns the Metro 2 format. Like, literally, it's their format. And he's just standing up there saying, like, but I mean, they report accurate data, when literally, if you compare the paper reports from the three bureaus, they all look different. Like, and I think that's part of it's like, I mean, when you understand who the guy is, he is the image of their data format. And he's saying, oh, well, but I mean, these people, how they report accurate. Dude, have you never looked at a credit report? I mean, it doesn't conform to what you are, which is Mr. Metro 2. But hey, as long as they keep on making those errors, it's good for all of us.
Yeah. It's sort of like somebody says, well, hey, John, you sue companies for fraud. What are you going to do when companies stop cheating people? Well, I guess I'll write wills or something. I'm not really worried about it, though, because there's too much money to be made by breaking the law.
We all want a utopian world until it affects our pocketbooks, right, John?
So let's see here. We have, I guess this is a collection law firm, Rubin and Rothman LLC, trying to collect a payment from me. I send them a dispute letter, and all they sent me were statements. I asked for more info and haven't heard from them. Should I be expecting them to sue me? So good questions. We've talked about this before. Unfortunately, when you ask for what typically is called debt validation, they don't necessarily have to send you a whole lot. I think they should have to send you more, but most judges say they don't have to send you very much. So the little trick that I have always used is whatever you ask for, explain why you need it. So you say you needed more than your statements. We'll say, I need X because of whatever. So if it's, let's say it's LVNV, portfolio recovery, some debt buyer, and they write you a letter and you say, hey, I want to see the purchase agreement where you bought this debt. Well, don't just say, I want to see the purchase agreement. Say, I need to see the purchase agreement because I need to know if you actually own this debt. Did you really buy it? Now, they're not going to give it to you, but at least you're making an explanation for why you need something. Again, imagine a judge reading it going, okay, yeah, that's reasonable. Or like we always ask for, give us all the statements from the last time it was at a zero balance to the current balance. We want all those statements so that we can see, have you properly applied the payments, the credits, the fees, the charges? Well, that makes sense, right? If they just sort of pop up with one statement that says you owe $5,433, well, how do we know that's true? Okay, so we want all the statements and we explain why we need things. And that can help you as far as whether they'll sue you. I'm assuming that's a collection law firm. And so generally when a collection law firm is writing you, yeah, they're looking to sue you. So kind of prepare yourself for that. Make sure you understand the rules in your state about your time limits to answer. And I would also look for a consumer lawyer in your state. And I'll put a link up. Let me see here.
While you're putting that link up, the other thing is you can get a much more powerful debt collection dispute by looking at the Bureau reports and tying in the inaccurate reporting with your debt collection dispute. Dear Mr. whatever this debt collector is called, the credit report shows that there's 2 different date opens. Do I in fact have 2 different accounts, or is it one? Can you please share that with me? Share me the contracts so I can feel comfortable that you're not lying to me. And also, if you were going to sue me, can you go ahead and tell me which state you would have, is in the contract? Where's my statute of limitations? I need the contract for that. And keep on going through the credit report. Inconsistent payment histories, inaccurate payment histories, different credit limits, things like that. These give you now legitimate things that you can prove. You can prove that it's on the credit report to now have a legitimate basis for disputing portions of the debt that they're trying to collect from you. And then if they come back with no, nothing, just, hey, here's a couple of statements. Well, that has not addressed any of the issues that you asked them. They may have sent you the last 20 statements, but you asked why there was 2 different date opens. You asked why there was 2 different high balances. You asked for an original contract to validate either is there an arbitration clause or not, right? So I think it's important not to underestimate the power of the data, even if you're not really, throwing it Metro 2 style. It's all really the same thing. But if you want to take it totally into a debt collection letter, use their own story against them, because what is credit data? Credit reporting is just a story of what's supposed to be a truthful, accurate historical record. So now if you've asked them all of these things and they disregarded you and didn't give you the answers, well, okay, they didn't necessarily give you the answers. And if you do a quick phone call to these goons and record it, if they're a debt collector, they can't make false or misleading statements, right? So now if you get them on a recorded call and ask them, well, where's my contract? What's my statute of limitations? What's the date of first delinquency? Why do I have 2 different dates open? Why is there all this missing payment history? Credit report shows the date was opened here, but clearly it was opened before. So what's going on? And now you're going to be able to, trip them up. And I don't like when I say the word trip them up, but because they just don't know what to answer. And if they're going to make a false or misleading statement to you, now you've got a lot more ammunition for when you go to a guy like John, right? And if you can record that phone call, hopefully you can then do a follow-up to the CFPB or maybe their executive and not have to go to a guy like John. But that's where when John's always saying it's about what you ask for. And I always say, look at the credit report. That gives us every single thing we need, especially if you understand what the Metro 2 format says. Here's all the data fields, and here's how they're supposed to report. Literally, it tells you what a 3-dimensional historical report should look like. And you look at these little piece of Swiss cheese paper reports that they give you, and just articulate that in a letter to these people, ask a bunch of questions. They're never going to answer it. And it gives you a lot more ammunition. What do you think about that, John?
Yeah. And I just put this up. This is an example that we see quite a bit. And so when you're looking at the report, and let's say the original creditor, it says, hey, we sold it on January 2020. Let's say sold or transferred to another lender. And then you look and you see, oh, portfolio, LVNV, whoever bought it. And you can match up those accounts exactly. But they say they received it December 2019. Well, that's one of those where you ask a question. You say, so I'm kind of confused. If you sold it in January, how did portfolio get it a month before that? Do they do time travel? What's going on here? And so now you're showing either the original creditor data is wrong or portfolios is wrong, or maybe they're both wrong, but you're pointing these things out. And look, you can do this through sort of the lens or the filter of Metro 2, or you can just do it in sort of everyday language. It's like, I'm confused. How did you sell something in January when you had already sold it in December? How did you buy it before it was sold? Normally, if I sell my house to Steven, he buys it after I sell it, not a month before I put it on the market. And so, you're looking for these inconsistencies, because when we find lots of inconsistencies, it makes us question the validity of everything else. And so, like in trial, we have a jury charge that says to the jury, if you find a witness lied about one thing, you are allowed to, not required, but you're allowed to presume they lied about everything else. And so if we can show there's this error and that error and this error over here and these 4 over here and these 5 over here, well, then it really calls into question, is this data accurate? And so it's very legitimate to make these disputes. Let's see here. We have Kim asked, portfolio suing me for Walmart Synchrony Bank with the wrong account number. They're misprinting it. Is it legal for them to redact it? Well, I would say those are two different things, Kim. If they are writing the incorrect account number, then that is certainly a matter of concern. Now, you have to make sure we're not confusing the Synchrony account number and the portfolio account number. But if portfolio is saying, well, this is your Synchrony bank account or credit card number, and it's wrong, then that definitely raises questions. Now, if they've just redacted everything, but the last 4 digits or the first 4 digits or whatever, that's something else. But if they have the wrong account number, it's legitimate for you to now say, guys, which one are you suing me for? Pull your credit reports, like Steven was saying. Is that old Synchrony account on there? I'll tell you this, a lot of times Synchrony goes away. Pretty smart for them to do it. They've sold it. What do they care? All they can possibly do is mess it up and get sued. So, if I was running Synchrony Bank, I'd be like, as soon as we sell it, boom, take it off the credit report. Like, it's not doing me any good as Synchrony Bank. But it gives you a basis. Look at those credit reports and see if you can figure out what's going on. And then you can ask questions in the lawsuit or through a dispute to portfolio or to a dispute through the credit bureaus or all the above about this. Hey, what's going on here? And so it's definitely worth sort of running those loose ends down and seeing, is it really inaccurate or not?
So, Kim, are you stating here that you received, like they sent you 2 different affidavits that were signed by their people? If that's the case, like if they were like, hey, here's our affidavits from Susie Q employee and John Doe employee with firsthand knowledge of this account and the account number is wrong, John, could that be considered a false or misleading statement by a debt collector potentially under the FDCPA?
Yeah, I mean, anything they say that's untrue, that's in the connection with collecting a debt, which obviously if they're suing you, they're trying to collect the debt, then that can potentially be enough to sue them. Now, again, we have to be careful because sometimes we look at our Synchrony number and then we look at our portfolio number. But if they're telling you what the Synchrony bank account number is and it's just flat out wrong, then, that can be a misstatement. Because, if I'm collecting a debt from Steven and I say, Steven, this is your Synchrony account number 1234, and he never had that, well, then I'm lying. Now, it may be unintentional. I may have some defenses to it, but it's just a flat out wrong statement. And it certainly makes you wonder, do they have you confused with somebody else? Are they mixing your file with somebody else? And so you need to know what portfolio is doing with that. And let's see here. So we have, John says, no contract, no debt. The bank never signs a contract. So I'll say this, if there's no contract, which I mean that in a legal sense, if there's no contract, that's a different question than whether there's a physical contract. If there's no contract, then yes, I agree. There's generally no debt. We can get sort of implied contracts, and like if you're in a wreck and they take you to the emergency room and they treat you, you didn't like make a contract with them, but the law implies one for you because they were helping you. But, we do have to be careful. Just because there's no written contract does not mean that there is no contract.
But let's talk about this. I mean, because if you're John talking about a credit card, I mean, there are so the three components, right? And I meant John McKay because you're John too, obviously. But the John W, the lawyer, there's really three components to a contract: offer, acceptance, and consideration. For it to be like legally binding, which all of that I'm sure is up to interpretation. But if you apply online for one of these credit cards, they've made you an offer, you've accepted it, and then there was consideration. They gave you the card, they gave you the ability to use it, you started using it. They can, obviously assuming that they can demonstrate, that you did sign it or e-sign it or accept it or whatever. I mean, assuming they have some sort of records to validate that there was some offer to you and the language and the disclosure. So John W., what do you have to say about that? Because I think that's something that's often misunderstood by people, is like the credit card company, they never signed anything. So how do we handle that issue?
Yeah, so we start with kind of a common sense approach. If I apply for a Discover card, they give me a Discover card, I use it to buy $10,000 worth of stuff. Will a judge really say, well, John, you don't owe that debt? No, because I got all the benefit from it. So from a legal standpoint, again, I apply, they accept. So we have the offer and acceptance. Consideration just means that I give something or I refrain from taking action. That's all consideration means under the law. So they give me a credit card and say, John, you can use this for $10,000. That's consideration. And so the contract is binding. There may not be anything signed with it. It may just say, hey, if we accept you and we send you this contract, then you're bound by these terms that will be emailed to you. Well, if I use the contract, the credit card, then I'm bound by that. I've accepted that. And so, and I'm not saying that John is making this argument, but I certainly have had a lot of people come to me and they say, hey, I got sued by Capital One. And so I say, well, did you have a Capital One card? And they say, it can never be proved. And I'm like, well, I'm sorry, maybe my question was confusing. Did you ever have a Capital One card? It can never be proved, John. I'm like, let me make this simple. Did you have a Capital One card in your wallet? Well,
what's in your wallet?
Yeah, what's in your wallet? It can't ever be proved, And I'm like, okay, that tells me you did have a Capital One card. They're like, but we went off the gold standard, so all debt is fake, and it's all, I didn't sign in blue ink, and, all of that may be fascinating sort of, intellectual exercises and thought experiments, but I can tell you that does not work in front of judges. A judge is going to take a very practical approach. It's like if I say, well, I don't think my mortgage is a valid debt because, the government's printing money. So I get my house for free. Judge is going to say, that's a cute argument, but no, you don't get your house for free.
Well, because what you would have to do, you would have to, if you're suing them, you would have to argue that the Federal Reserve notes themselves are not constitutional or legal tender or whatever. Like if your argument is, well, they print the debt and they create the money and it's all fiat currency, which I tend to agree on all those things. But if you're like saying, well, they didn't give me anything of value because they gave me a Federal Reserve note. But, well, why was that not of value? Well, because Federal Reserve notes are actually debt instruments. Did you sue and basically allege that Federal Reserve notes are not legal tender? So, if they're going to go down that rabbit trail, John, that's really right. Like what they would have to argue for the judge to even entertain that is they would have to argue that Federal Reserve notes are not even legal tender to be able to then get to the point to where, well, there was like no consideration because they gave me a debt instrument, right? We're not even putting that in the lawsuits when most people want to try to make that complaint, and so we just don't even get to that point, right?
Yeah, and look, it comes down to sort of a practical thing. If we say, and there are some legitimate arguments to make this point that our standard of currency and how we print money and all this. There are all sorts of problems with it. Hey, I think there's some legitimate arguments about that. But if we're using that, so we're using that credit card, whatever you want to think about US dollars, we took those and we bought a car. Judges are going to say, guess what? You're in the game. And so you have to, live by that. And now we can sit around and say, well, if we were starting all over, maybe we wouldn't leave the gold standard, for example. But, this is the reality we're in. And so anyway, it's a fascinating, kind of topic. But again, I'm just telling you from doing this for many years, seeing all these types of arguments made, and the judges, whether right or wrong, you can disagree with them, but the judges will say, did you have a credit card in your wallet? Did you use it? Did you pay it back? You lose. Okay.
Can you imagine?
They're not particularly interested in, fiat and, the way the monetary system is set up.
Yeah, can you imagine that poor bastard of a judge that decides to make the ruling that Federal Reserve notes are in fact unconstitutional? Boy, that judge is going to get suicided in no time. You know what I mean? There are just certain things that you can't really fight the tide, as they say, right?
Yeah, and I'll tell you this. So we'll come to this question in a moment. This is back in about 07, 08. We were involved in a case involving mortgages. Okay, and I won't go down this whole rabbit trail, but basically mortgages are bundled together and they're securitized. And then all these bundles of mortgages are put into a trust, okay, that then people invest in. And we were able to show that all these loans, might have been 100 loans, 1,000 loans, were put into the trust in violation of not only the trust document, but the IRS regulations, okay? Which means really they're void, okay? Which means that you don't owe anything on your house. The problem is it was too good of an argument. And even though the judges understood what we were saying, no judge is going to be that judge that says, you know what, I rule that 60% of all mortgages are invalid now. It would destroy the country, okay? And even if one judge did that, boom, they would be reversed so quickly. So, I've had things in my career where we have filed lots of lawsuits. We have a great lawsuit, and, Dick Cheney gets involved and says, hey, I want the HUD department to change these rules and make it retroactive and wipe out all these lawsuits. It happens, okay? So we're sort of operating within the boundaries of practical terms here. And one thing, I missed a question about, can an original creditor sue more than like 2 years after? Yeah, well, I said something about they always sue within 1 year. I don't mean that they literally always do that, but in my experience, they very often do that. So the question is, within the statute of limitations, where we see companies filing lawsuits years and years and years afterwards tends to be the debt buyers. So that's the only point I was making there. Let's see here. Sharon says, Synchrony Bank sold my debt to Midland Credit, but the account is 6 years. And we may have lost the rest of it there. But so the question is going to be, they can sell the debt if they truly sold it, but Midland's got to prove that they bought it if they sue you in court. Then the question is going to be, did Midland file the lawsuit in time? And if they didn't, then let me just take a step back. There's 3 time periods. There's time period to sue. That's statute of limitations. Time period to credit report. That's what we call the obsolescence period, basically 7 years after default. Then there's just the time period to collect, to call you, to write you. That's really unlimited, but they have to be careful that they don't suggest they might credit report. I mean, I sued a company recently because it was like 10 years after we stopped paying, and they said, please be advised, we may credit report on you. What do you mean you make credit report? It's impossible to credit report on me 10 years afterwards. So that's a lie. So we're suing you for that. So
Well, no, maybe they were telling you the truth and they were just admitting that they were going to violate the FCRA. That would be their defense if you sue them, right? They were like, no, we weren't lying. We were just going to tell you we were going to violate the FCRA.
It's funny you argue that, Stephen, because we have sued debt collectors and we say, you threatened to do something you had no legal right to do. And they go, well, here's our defense. We did it. We did break the law. That's our defense. Well, FDCPA covers that as well. So it's not really a good argument.
Leave it up to the lawyers to keep this world entertaining, huh, John?
Yeah. So here's Deandra. Hey, good to see you, Deandra. Let's see. I filed CFPB complaint, Convergent Outsourcing. They replied to the complaint saying they will cease collection, remove it. How do I settle without them adding it back? So I guess my question would be, why would you want to settle with Convergent if they are stopping collection and removing it?
I mean, she may be concerned that they're going to hot potato it back up to the creditor. So they're just going to stop collecting and hand it back if they're a collector versus a buyer, I guess. So,
yeah, and even if they're a buyer, they may sell it to somebody else. And so sometimes you want to catch these guys when they're breaking the law and they're going to break the law. Just go ahead and sue them. And then you can sort of wrap your hands around them and kill the debt, get money out of them, get off the credit report. But maybe Deandra, if you get a moment, give us a little bit more information.
Yeah, she just messaged down there. She says, well, they are probably going to sell it to another collector. Yeah, so that's
okay.
Yeah, that's her concern. Yeah, I mean, what I would say is you probably don't have very much except just to wait to see if they do that. I mean, if they're saying, hey, we're going to stop collecting it and delete it, I mean, that's what we call whack-a-mole. The old whack-a-mole game. It goes down the hole and it pops up again. But then if it gets re-reported by the new collector, is it reporting as in dispute because they bought a disputed debt? John, let's talk about that. So if a debt that's been disputed is transferred to another furnisher and it's reported as a brand new trade line in the name of the new furnisher, not showing as in dispute, what are the precedents as far as, do you have to put that new creditor on notice, or should that dispute transfer over as a component of the attribute of the debt when they report it?
If I was writing the law, it should
no.
over.
As
but
50 years of precedents have badly interpreted the law. That's what we want to
do. The reality is judges say you would have to notify the new company and let them know you dispute it. So like, here's one strategy. Give you an example. You're dealing with a cable company. This is sort of the classic thing.
Cable? Nobody uses cable anymore.
Cable, DSL, broadband. You got the gateway from AT&T. And they say, Stephen, when you moved, you didn't return the box. And so they send it to a collector and you dispute it and they go away. And then it goes to another collector and you dispute it and they go away. So how do you stop this whack-a-mole? Well, if you really did return it, instead of disputing it with these collectors, just sue the collector. Because they say, Stephen, that you owe $150 for the gateway, the router, whatever. That's not true because you returned the equipment. So you sue the collector. And then you go after DirecTV or Comcast or whoever it is in arbitration and say, hey, guys, y'all are transferring this debt to people. This is not true. And so you sort of go after them both ways. So you sort of whack each collector, but then you also go back to the source. And sometimes we call this the kill the king strategy. You got to go back to the original source, go after that company, make them kill the debt. And so you never have to deal with it again, because this whack-a-mole is a very frustrating thing. And say you're trying to buy a house. And so you don't know when it's going to just pop up on your credit report with a new collector. So sue every collector that you deal with and go attack the source of this. And that can certainly be one way to do it. Let's see here.
Let me ask you this. So when Deandra gets this letter from Convergent via the CFPB where they're like, we're going to cease collection and close the account, can she send them a follow-up letter and ask them what's going to be the status of it? And are they obligated to respond? Like, okay, I mean, are you going to keep it here and it's dead, or do you have intentions of selling it? Did you already sell it? Like, can she have any follow-up ammunition with them, or is she pretty much just stuck until the whack-a-mole pops up anywhere.
Yeah, it's a good point. You can ask them those questions. And look, if you don't owe the debt, you can always sue them. I mean, if you truly don't owe the debt, even though they go, okay, we're ceasing collection.
Dude, but that's not nearly as exciting as suing them when you do owe the debt. I mean, let's just be honest here, John. You know, we want to sue them when we do owe the debt, right?
You know, but if you even if you owe the debt, you can sue them if they violate the law. So you have to find a violation. The easiest violation is you don't owe the debt and they claim you do. But I mean, we had a jury trial once, and we clearly owed the debt, no question about it. But the collector broke the law, and I remember the jury came back with a question. They said, "Can we award money to the plaintiff's lawyers?" That was us, and not to the plaintiff. We want to award a verdict against the defendant, but we don't want the plaintiff to get any, which was, I thought, a very unusual question. But the point is, they're like, "Hey, this consumer owed the debt. We don't really want them to get any money, but we really want to hammer the collector." Okay. Now, the answer to that question is no, you can't do that. You have to award it to the plaintiff. But just because we owe the debt, you know, I mean, most of our FDCPA, Fair Debt Collection Practices Act cases, we owe the debt to somebody, but that collector has broken the law. And so that's the thing I would look at. Is it's just the easiest way to stop that whack-a-mole is find some violation and sue them, because if they're collecting, they have an obligation to have no violations of the law. And if they do, violate the law, sue them.
If we could take the mindset as we're approaching these folks, which is what you lawyers love, which is what are my damages? And you love it because that's really what the judges want to see. How has the consumer been damaged? So like if Cassandra, where she's got this notice from Convergent and they're like, we're going to close it, we're going to cease collecting or whatever the case, you know, did you frame this thing up from the beginning with your dispute? Hey, I'm being damaged for the following reasons. I'm trying to get a mortgage and this is reporting inaccurately for the following specific reasons with your data. And clearly this is going to affect my score. So please fix it within 30 days and give me an accurate score and data or delete it. And then if they come back and they delete it, you know, maybe you can send them a follow-up letter. I don't know, John, could she send a follow-up letter if she's really worried about it, saying, you know, dear Convergent CEO guru, thank you so much for notifying me that you're going to delete it and close it. And just to reiterate, so you guys are aware, you know, I'm being damaged by that. And so I appreciate you removing that. And, you know, if you're going to do something else with it, can you let me know? And can you let them know that I disputed? Like, how could she use the damages to tee this thing up to where, I mean, let's say it is a critical deal. You know, you're getting ready to close on a mortgage, right? And then you get this notice from Convergent. You're like, yes. And then one day before closing, they re-pull your credit report and this new nasty ass thing pops up in your credit, right? This is a very real issue, right? This is something that concerns a lot of people because it's a real deal. It could pop back up. I mean,
it happens.
How could she kind of anticipate with the next letter, but where it's a legitimate letter, to where then an attorney like you would have something where you could call up the new furnisher and be like, look, man, we need to handle this like right away or else it's going to be, you know, not good news because this lady is trying to close, you know, tomorrow.
Yeah. So if you can't sue, you know, I've already talked about that option. Send a letter certified to Convergent if there's an original creditor that is still involved. In other words, if Convergent hasn't bought it, send a letter to Convergent and the original creditor and just explain what's going on and say, look, I'm in the middle of buying a house. It's really going to be a nightmare. Don't send this out to anybody else. I don't owe this, or whatever the situation is. But ultimately you can't stop them from reporting on your credit. You know, this isn't some, you know, crazy thing where like we freeze our Sage Stream account or our LexisNexis and now they can't. No, none of that. I mean, we can't prevent them from putting it on. But if we lay the foundation with the letters, just explaining to them, don't send this to anybody else. This is wrong. You have the incorrect amount, whatever it is. Then if they do that, you have to sue. But again, particularly if we're trying to buy a house, you know, if there's any wrongdoing, I just think it's easier to sue them because then you control the story. And particularly if you can reach out and grab that original creditor too, if they still own the debt. And once you squeeze them, they won't send it to anybody else. And so that can be something. You know, here's Carlos says, federal notes topic too deep. Yeah, and look, it's a fascinating thing, and I see some comments on here. It's just not really the focus of this show or this channel to delve into that. But look, it's a very interesting thought exercise. We just don't want to confuse that with standing in front of a guy or a gal in black robes, with a gavel in their hand. So
We've got this phrase in this country and in this world: money talks and bull hockey walks. And if you want to go ahead and challenge the financial system and its constitutionality, which I completely agree with everything you guys are saying, that'll be probably the last ruling that judge ever makes above earth. So there is certain things in this world that are just not fair, unfortunately. So how do you play the game within the scope of how we can play that? And I think that's an important point, right, John? I mean, we can sit here and argue, hell, how many laws are in fact probably unconstitutional? Probably a big portion of the U.S. code is somewhat unconstitutional, but I mean, what are you going to do, right? How do you make it work? So
yeah, and so
is making it work with what you have, and
yeah,
acting smart with the tools that we have to deal with.
That's right. Now I'll just give everybody this one example, and then we'll move on from this. There's something called the Interstate Commerce Clause. It's in the Constitution. It says Congress has the right, basically, to legislate anything involving interstate commerce. Well, what's interstate commerce? Well, there was a case the U.S. Supreme Court decided, and I forget all the details, but it was, I think somebody was growing wheat beside their house. And so ultimately the question was, could the courts regulate that? Could Congress regulate that? Seems pretty, like within a state. But the argument was, well, it might somehow affect the flow of wheat around the country. And so just with that one ruling, now Congress has extraordinary power to basically do whatever they want. I mean, think about, well, what's happening with your kid in school? Well, that could affect interstate commerce. I think that is a very suspect ruling, okay? But that's never going to change, at least not in my lifetime. It's not going to change because the whole government now is built on that. So we can say, well, that's unfair and we don't like that. Well, that's okay. If we don't want to be subject to it, then we leave the country, okay? But if we're going to stay here, we've got to operate within sort of the realities of the Supreme Court says this is what the law is. And understand this, judges, there's something called a legal fiction. And that expression just means it's the law, even though we all know it's not really accurate. But there's a legal fiction that says judges never make the law. They merely discover what the law is. So when maybe there's been precedent for 50 years and then it changes, well, they're not really changing the law. They just discovered that they've been wrong for the last 50 years. And occasionally judges will say, hey, look, we were wrong. We said this was the law. It's actually not the law. Now we're telling you what the law is. So, but look, that's for a different subject here. Let's see. Deandra says they violated 1692G. So yeah, look, and that has to do with validation and things of that nature. If they're violating the law, then I would sue them. And that's the best way to sort of grab hold of them so that you don't have to deal with this popping up again. Let's see. Elm says, I'm in Georgia, so my car, my car has been in repo for 4 years, past statute of limitation, time barred. Does that suspend the repo? So I'm not entirely sure what you mean by this.
What he's saying is he's got a vehicle that he still is in possession of, and they've been trying to repo it for 4 years.
Okay. So statute of limitations is a time period to sue. Repossession is generally not a lawsuit. That's what we call self-help, and they can just come repo it. You'd have to look in Georgia if there's a specific law. I doubt there's a law that says, they have to repo it within a certain period of time. They may not can sue you for the dollar amount, but they probably can still repo it. Now, there is something called replevin, which is we file a lawsuit to have a judge say we get possession of an item. So that's kind of the judicial form of repossession. But I would just get with the Georgia lawyer about that and sort of find out, what your options are there. Let's see. Deandra says, Stephen, we'll let you do this one. Can you speak on why freezing, opting out of the secondary bureaus is pointless? That advice was given to me when began this repair process. So I think that's a very good question.
Yeah, it is. It's actually a really good topic, and it seems like we always talk about this. So I agree that freezing a report is not going to help you with repairing it, which is kind of contrary to what our industry, credit repair industry, will tell you. But what you have to consider is that, like, if you take somebody like LexisNexis, they act in a dual role. So they're a consumer reporting agency, which the freeze enables the consumer to freeze the consumer report from being prepared by a consumer reporting agency. It's designed to keep them from preparing reports and you getting fraudulent credit opened up in your name. So if a consumer reporting agency can't prepare a consumer report, which a consumer report is specifically defined in the FCRA as, a report of your information provided to somebody who's going to make a credit evaluation and so forth. But then LexisNexis, as the example, it could be SageStream or whoever else, but they also would act in a separate capacity as a data furnisher. And so the freeze is part of the FCRA. It's also in your state laws, but now it's also in the FCRA, and it's very specific to freezing with consumer reporting agencies, your consumer report. So they have this database full of data. It's the same data, but then how they use it is in different capacities. So if you freeze it from them being able to, prohibiting them from producing a consumer report, that still does not prohibit them from furnishing data. So if LexisNexis, as the example, is furnishing data to the other bureaus, if you've been able to successfully freeze it, they can still furnish data. So, I know a lot of people say they freeze reports and they think it does them good. I don't know. I don't have any sort of statistical evidence on, I don't freeze bureaus. I don't believe that there's any direct correlation between freezing a report and the outcomes that these people speak of. But I would say that I would believe, I'm not a lawyer or anything like that, but if I were the lawyer, I would think that they were under no obligation to not furnish, even if it was frozen. John, what do you say about that?
Yeah, so you have, for example, LexisNexis, they can furnish information. They can be a credit bureau. They can also be a vendor where Equifax hires them, for example, to go search for your bankruptcy. And people say, oh, well, I froze LexisNexis, so they can't supply that information as a furnisher or a vendor to Equifax, Experian, TransUnion. Well, they can because they wear different hats. And the whole idea of freezing is, like Stephen said, it's if you think maybe you're going to be the victim of identity theft. It's not to somehow jam up the bureaus. And, Equifax can always go hire somebody to look up the court records, bankruptcy records, look on PACER, the federal court system. So does it ever work? Well, I'm sure it does. If I send in a handwritten dispute, I might get good results. And then I say, oh, it's because I handwrote my dispute. Or I might send it in on pink paper. And I go, I got things deleted, so pink paper is the answer. Well, that's kind of confusing correlation with causation. I may have done something and there's a good result, but did it cause it? So to me, if somebody wants to freeze their LexisNexis, they have the right to do that. SageStream, God bless you if you want to do it. I just don't think it really gives you any benefit. But if somebody thinks it does, then, that's fine. I'm just always skeptical of, the people that are sort of selling I've got the secret here. If you pay me this money, I'll give you my secret freezing letter. There are no secrets in this. It's finding errors. It's identifying the errors in a clear, simple, easy to understand way. And then the bureaus don't fix it. The furnishers don't fix it, and you sue them. That's the simple answer here. I saw somebody put a question up about there's ambiguity between that's a violation of the FDCPA, FCRA, and there's so many violations that the attorney will take it on contingency. What do we do in the middle? So here's what I would say about that. Not every violation should be sued on. Okay. Let me give you sort of a ridiculous example. A collector sends me a letter and says, John, you owe $10,000 and 1 penny. And I go, actually, I owe $10,000 and no penny. I want to sue you on that. I don't think you're going to get very far with that, to say, well, it's off by 1 penny. Okay. So we have to use some judgment in it. And there's other times where we say, hey, yeah, technically this is a violation. I'll give you an example. Here's a very technical violation, and I want to sue this company that could do a $20,000 counterclaim against me. Well, I'm going to say as a lawyer, well, maybe we don't need to do that. Maybe that's not the smartest thing to do, to go in with a $5,000 lawsuit when they can sue me for 20. That may not be very smart. So, we first start with, is there a violation? Do I have a clear violation? And then do I have damages? What are my damages? Economic damages, emotional damages, statutory damages. Maybe I have punitive damages. And, there are times where we say, we just don't think this is worth it. It's really not, at least for most lawyers, it's not, well, I don't think I'm going to make any money on it. It's, is this worth it for the client? Okay. Now, there are some lawyers that, will say, I only take, 6-figure cases. And when I've heard them talk about that, they say, if I take a smaller case, it will damage my brand. It'll hurt my credibility. And look, if they believe it, then I guess it's true for them. It's factually not true. Okay. And I can give you the example, John Morgan and Morgan & Morgan, they have revenue of $1 billion a year. They're the largest injury law firm. So I'm talking about personal injury, largest injury law firm. They take very small cases. They're not worried about, if they have a $20 million case, somebody going, yeah, but, Mr. Morgan, you took a small case last week. It's like, I don't care. I take small cases, big cases. So most consumer lawyers, I think, are smart enough to know if there's a clear violation and this is a legitimate case, it's not posing a danger to their client, they'll take even so-called small cases. There's an expression by a great PI lawyer named Don Keenan in Atlanta, and he says there are no small cases, only small lawyers. And that's a pretty good expression, and particularly on these consumer cases, it might be a case that should settle for $5,000. If they won't settle with us and we go to trial, we may have $100,000 in fees by the time. So, it's even better than, quote, small personal injury cases. So to answer your question, Drew, I'd just say, get with a lawyer in your state. If you have a consumer lawyer in your state, and say, hey, is this a violation? Are you interested in it? If not, why not? And sometimes it's, lawyers view things differently. Sometimes lawyers just don't maybe appreciate emotional distress damages, or maybe in their state, judges are very harsh on that. So you do have to know kind of the battleground there. So that's what I would suggest doing. Let's see. Here's one. Stephen, I have questions regarding the Fair Debt Credit Reporting Act, which will not handle a case long as you have an appeal. How do we get around that as a way to file a countersuit? So this is on a wrongful foreclosure case. So I'll say this. It sounds like you were sued in a what's called judicial foreclosure. It's like in Florida, New York, where they file a lawsuit to foreclose. Stephen, where you are in Alabama, where I am in Alabama. I mean, you're in Texas. I'm in Alabama.
I'm in the great Republic of Texas, buddy, but yeah. I still love Alabama.
Yeah. So we have non-judicial foreclosure. We don't file a lawsuit. At least I don't think you guys do in Texas. And so it's sort of like a repossession. But if you lost the foreclosure,
they just come with the SWAT team and smoke your ass out of the house here.
Yeah, to some
smoke bomb through the window.
But if you have a judicial foreclosure and you lose that, then it can be very challenging whether or not you can bring a counterclaim, or do you have to appeal it? And you really have to dive into your own state's laws on that, because it gets very sort of technical. So here's somebody never freezed a bureau yet, still get results. Yeah, I think that the freezing doesn't do a whole lot. Let's see. Tony said driving, can't go back, chat, see, put information. So, Tony, what I would just say with that is get with the consumer lawyer in your state, because when we're dealing with foreclosures, that is super state specific. I mean, a foreclosure in Alabama may be radically different than a foreclosure in Tennessee. You know, Texas versus Louisiana, they're sitting right there, but they're fundamentally different. Florida and Georgia, totally different foreclosure. And so you really have to get with somebody local there. So Stephen, let's see here. I'll need to hop off here in just a few minutes. I suspect you do as well. Let's see. Sharon says, my question, can Midland Credit still come after me? Statute of limitations has been reached, which is 5 years in Florida. So if you're beyond 5 years and they haven't sued you, then they can't sue you, or if they do, you sue them. You know, Stephen, explain how long can Midland credit report, even if they're beyond the statute of limitations? How long can they credit report?
Yeah, that's that obsolescence period that you were talking about earlier. And essentially, it's spelled out in the FCRA in 1681C. And they can report it for 7 years and then an extra potential 6 months. So basically, they have like 6 months from the time that it goes delinquent. And then after that 180-day period for credit reporting purposes, it's got to be considered a negative account, a collection account for credit reporting. Like if they put it for internal collection after 180 days, that's when that 7-year clock. So really it can report for 7.5 years is the maximum amount. A lot of the bureaus will actually purge them out a little bit before 7 years. They kind of have internal policies. 6 years and 8 months, you know, they're all different. But under the FCRA, 7 years plus an extra 180 days.
Yeah, so just keep an eye on that. And, you know, if you're beyond the statute of limitations and Midland says, hey, we may garnish you, we may sue you, then you need to get with a Florida lawyer about that. And we know some good Florida lawyers. Just get with me. Let's see. Golden Gate says, sued by Bank of America for charged off credit card. Answered, asked for a hearing is far out due to COVID with the intent to settle before the hearing. Will the collection attorney settle for a lower amount closer to the hearing date? You know, they may. There are some original creditors that sort of use a chart, and the further out from the date of default, the sort of lower percentage the lawyer can go. But in general, I don't think you're going to necessarily get a better settlement closer to the hearing unless they run into a problem with their witnesses. Like maybe they need to bring a live witness and they can't. Well, that will cause stress among the collection lawyers. So, you know, I would just sort of figure out what you can afford to pay, what your strategy is to talk to them. And, you know, if you wait till right before the hearing, you may get a better deal, but you may also create more stress for yourself. So just make sure that you're comfortable doing that and sort of getting right up to the edge. And, you know, that may be effective for you. Here's a CFPB question for you, Stephen. If you have a record of the debt collection agency violating the FDCPA, can you use the CFPB to collect monetary damages? It's a very interesting question, and
No.
Appreciate that.
No. You could use them to try to, I mean, compel some sort of a resolution, like stop collecting if they say they're going to cease it, or to delete it off of your report. But I mean, the CFPB really just kind of acts as a middleman conduit, kind of. Yeah, they're just going to forward your dispute to the debt collector and then forward the debt collector's response back to you. So, I mean, I doubt that the debt collector would offer to pay you some sort of damages from the CFPB, because like the CFPB isn't representing you, they're not your attorney or nothing like that. And it's not going to put them really like in a better position in front of the CFPB to be like, oh, look, we just acknowledged that we messed up and we're going to pay you. So I would say, no, your best avenue for the CFPB is to really just try to get, like, you know, some sort of a reasonable resolution. What are you really looking for? Like, are you looking for them to stop collecting, or are you looking for them to remove it from your credit? I think that's probably where you would be best suited to leverage the CFPB. What are your thoughts, John?
Yeah, and look, occasionally the CFPB will go after companies, and they may recover some money and they may distribute some of that to consumers, but that's the context. I mean, if you have the collection agency violating the law, the best solution is almost always to sue them. So, not sound like a broken record, get with the consumer lawyer in your state, say, here's what happened, here's what I think the violation is, and see if the lawyer agrees. And if they do, then sue them. Because like Stephen said, CFPB is really to receive complaints and they do their own investigation. But, and this is nothing negative toward the CFPB, they are not so much concerned with sort of getting justice for you. They're trying to identify the really bad actors that are cheating 1,000 people, 10,000 people, 100,000 people, and get relief for them. If you want your own relief, you go sue them in court. And that would be my advice for you. Let's see. Drew said, thank you. I'm working with someone right now. So this was about a lawyer, and yeah, so that's great. If you've got a lawyer, just get a good relationship and push forward with that. Here's Samantha saying, have you heard of a judge denying a motion to dismiss on a case where you claim you've not been served? I filed lack of jurisdiction, lack of process in Indiana. So I don't practice in Indiana. I can tell you in most states, though, they're going to have personal jurisdiction. If you live in Indiana and they sue you in Indiana, the court has jurisdiction over you. Question is, were you properly served? So if you say you haven't been served, then you really want to prove that. Okay. So maybe they served you supposedly by certified mail and the certified mail card isn't signed. Well, that may be pretty good in your state. Maybe they gave it to somebody who lives at the house you used to live at 3 years ago. I can tell you in Alabama, that would not be good service. I presume it would not be good in Indiana. So you may get an affidavit from that person that they actually served and say, hey, Samantha doesn't live here. She hasn't lived here for 3 years. I told them I wasn't Samantha, and they said, here's the paper anyway. So in other words, you want to put that proof in front of the judge and, obviously get with the lawyer in Indiana, find out what the custom is, what the practice is. And it may be if you just said, hey, I wasn't served without proof, the judge may just say, yeah, I'm disregarding that. And so you definitely want to put proof in front of them. Let's see. Carlos says, several attorneys I could have settled better than them. Well, that's unfortunate. So I think if you're in New Jersey, Carlos, if you need some lawyers there, just reach out to me, and I know a couple people there that could help you. And let's see, Mr. Knott, what's the name of the law that states credit bureaus can't report your information without your permission? So, Stephen, I am very curious. What's the name of that law that says the credit bureaus can't report your information without your permission?
Well, there's a law that says they can report it without your permission, and that's the FCRA. Unfortunately,
yeah,
there is no such law.
Yeah, and that's the thing. I know not everybody's been with us this whole time, but I spoke a little bit ago about sort of the contempt or the condescending way these credit bureaus treat us as consumers. And I've got I think it's an 18-minute video coming out tomorrow morning on this on my YouTube channel. But think about this. You have no say in whether or not Equifax, Experian, TransUnion will report on you. You can't stop them from reporting on you. They absolutely can report on you. The only thing you can do is when you find errors, you can say, guys, you messed up. And so you would think if you have no control over them reporting, when you do point out errors, they should be like, man, we are going to jump on this. We're going to treat it very seriously and really, really investigate. And when they don't, it's like, good grief. You guys didn't ask me for permission to report. I mean, you're not even investigating when I tell you about the problem. So unfortunately, they can report without your permission. But when they do errors, sometimes you can sue them just for that, but usually need to dispute. And that's really the way you hold their feet to the fire, is sue them when they don't do the right thing. Let's see. Drew said Bank of America attorney more likely to go for summary judgment. That goes back to, I think Golden Gate was asking if you get right up to the hearing date. So yeah, sometimes they do file for summary judgment. Let's see. Samantha, this is on that service issue. Sheriff never left the complaint. You showed proof. Judge denied it. Sometimes judges get the wrong decision. Generally, something like that, you can't appeal immediately. You got to go through the case, unfortunately. So sorry about that.
That's when you know that debt collector contributed to the judge's reelection campaign.
Well, that's a pretty cynical approach. We certainly hope that all judges are very honorable, and
yeah, right, huh? Exactly.
That's what we need. So let's see. Elm says repos are a part of or not a part of deficiency, which can be time barred. So let me say this: you get your car repoed, they sell it, you owe $10,000, they sell it for $5,000, so you have $5,000 deficiency. I think most states would be if by the time they repoed it, it was beyond the statute of limitation. I don't think they get to now sue you for the deficiency. But again, you'd have to check. States can vary on this. There's something called the Uniform Commercial Code. It's supposed to be uniform across all states. It's anything but uniform. Okay.
Kind of like the Fair Credit Reporting Act is supposed to make it fair credit reporting.
Yeah, and it's supposed to be the same all over the state, but it's not. I mean, it can be radically different if you're out west versus the East Coast, and so you just have to know what your laws are there. Let's see. Did you say that court has personal jurisdiction without proper service? So, yeah, not to get too deep into this, but there's subject matter jurisdiction, then there's personal jurisdiction. So subject matter jurisdiction is power over the case. Okay, so most state courts are what are called general jurisdiction courts, so they can hear a case. For personal jurisdiction, they do have to serve me in order to have personal jurisdiction. And so if I said a minute ago that they can have personal jurisdiction without you being served, I was wrong when I said that. What I meant was there's general jurisdiction. So sometimes people will say, I challenge the jurisdiction of this court over a collection case. Well, they have jurisdiction. They may not have served you, so they may not have personal jurisdiction over you, but they can still have what's called subject matter jurisdiction. So I may have just confused everybody more. If anybody's interested in that, I'll do a quick video on it.
So Mr. Wallace, what you're saying is previously you misspoke.
I may have misspoke, yeah. The problem with not being able to remember past 2 minutes ago is I honestly have no idea. But
Mr. Watts, if you'd like, we can go ahead and pull the transcript and tell you exactly what you said.
Yeah, I'll say this. I have confidence in Kenneth, and if Kenneth says that I said that, I don't dispute that. I will trust Kenneth on that, and just we're going to move to strike the previous statements, and the jury will disregard that.
You're going to unhear what you just heard. Okay, that's how that's going to work. But you just said he killed her and dumped the body in the swamp.
That's right.
Unhear that. Okay, don't let that sway your decision, jury.
So let's see, Kenneth. Thank you for clearing. I think Kenneth's being very kind to me.
Oh yeah, we love Kenneth.
So let's see. Somebody said, "What's your YouTube channel name?" Since Stephen is always sharing his plug. Well, isn't that the truth?
Elvis Garcia.
Yeah, that's a very, very observant guy. He is always, forcing me to share his stuff here. So, I think if you let me see here. I tried to make a shortcut. Let's see if this works.
Well, Elvis, clearly my self plugs aren't good enough because you haven't gone to PalmieriSystemDemo.com and signed up for my Palmieri system software. So I'm going to have to keep plugging myself until you become a software subscriber. But this isn't about me, John. This is about you. Go ahead, John, plug yourself.
Yeah, so if we go to John Watts Videos, that should take you to my YouTube channel. And, although I'm getting some kind of error message on Facebook for some reason, who knows? But just go to YouTube and search me. And so hopefully that will be a much more satisfying experience than some Palmieri demo. Look, the guy's got let me see here.
I've got
Share my screen real quick.
I've got a funnel page for everything. Do you want to go to my training? Go to creditrepairtrainingcourse.com. But Elvis, you're already in that one. So that wasn't a plug. That was just a statement of fact right there, John.
Yeah. So see, he's got this software. He's got Stephen Palmieri. He's got like a store with hats or something.
Swag.
You still have your hats?
Oh yeah, we've got them up there. Go down to the bottom.
Yeah, everybody ordered this free MacBook for $99. It's a great deal. It's a brand new MacBook, and don't let him tell you it's not what that is. I can clearly see it on there. So
look at that. Look at the swag. Get you some baseball caps. Get you some shirts.
Yeah, that's
look at that. That's everything you need.
We got $1. What's his dollar?
Yeah, that shouldn't be up there. That's all
right, we'll scroll down real quick. Get rid of that.
My developers have to get fired over that.
And
this is small business entrepreneurship. You see, this is how we keep it real. It's not the most perfect presentation for you guys.
Yeah. Watching sausage made is always disturbing.
That's right.
All right. Well, hey guys, thanks so much for being on here. And I think we've got so we'll stop the sharing of the screen, and we'll end it. This is a great way to we actually may have something else here. We'll wrap these up real quick. Sharon says, can you give me some names of the lawyers? I live in Cocoa Beach. So you could check out Mike Waslick. He's in the Tampa area in Pasco County. So it'd be a few counties over from you in Cocoa Beach. Why am I drawing a blank on our guy in Clearwater?
You're looking for Aaron?
Yeah, Aaron Swift. I'm sorry, Aaron. I could see him, and Aaron's a great guy. I just couldn't think of his name real quick. But Aaron Swift is in Clearwater, so I guess that would be I don't know if he's still in Pasco County or it might be Pinellas or whatever, but so I don't know anybody specifically in the greater Orlando area, but check out one of those two guys, and if they can't help you, they could probably tell you who could help you. And they look, if it's sort of related to debt defense, like you're being sued by Midland, they probably handle it all over the state. I know in Alabama we handle it statewide, so. Just check out those guys. They're both just super guys. And let's see, Drude says, Steve Software have a differentiated price point for a one-time user versus an attorney? That's a great question. So, Stephen,
really it's not a consumer software. It's for businesses, for credit repair companies or attorneys. Now, that being said, the only thing required for you to open up a lemonade stand is to make some lemonade and put up a stand. So you can be a consumer and still have a sole proprietorship. Wink, wink, wink. You can be in business, which actually a lot of people get into business being their own first customers. But as far as the price point, it's you get a free trial, and after that, it's if you have under 99 active clients per month, which you would be there, it's just $99 a month. So, yeah, reach out to me. You can go to palmierisystemdemo.com. It'll bring you through if you want to sign up for the free trial. I'll see it come over. I'm happy to do a walkthrough for you on that, or shoot me a message on Facebook. But yeah, would love to talk with you. And who knows, maybe it'll turn into a Plan B side business for you as well. That's how a lot of people get into this business. So
that's right. So right now he only wants to make lemonade once for himself, but you could use it and use it for a month or so. It's not really the best way to use the software, I don't think, but I'll say this: Stephen's very generous. If you set up a call with him, he'll chat with you about this, and he's been doing credit repair for a long time there. So we got Carlos. Thank you both. You're very welcome, and thank you guys. Great show. So hey, it's a good show because Stephen and I don't have to sit here and just talk to each other for 2 hours. We just answer questions, and that's enjoyable, and hopefully it's helpful for everybody. And we will catch you guys. Are we doing this again in 2 weeks?
We're doing it. Well, what is 2 weeks? Does this month have 4 or 5 weeks in it? Hold on, let me pull up the calendar because it's not bi-weekly. It's twice a month. Let's see. So we do this the 2nd and 4th. So we'll be doing this actually in 3 weeks. Okay, so we'll be back here in 3 weeks.
Okay, so are you
Unless
having?
you want to do a bonus? You want to do a bonus next week? Because next week is actually, I don't have anything scheduled because that's the 5th wheel. So
Yeah,
we can do it next week if you want to.
yeah. So everybody just sort of keep up with my channel or Steven's Facebook group, because I know one time you had didn't you have Brian Ponder on the last?
We did. I did that on the bonus. Yeah.
Yeah. So
yeah. I'll reach out to them too. So that's the good thing, guys, about watching us is literally we're here live on the air. Neither John nor I know what the hell is going on.
There's no scripting to this. You know, Kenneth could testify to that, since I, completely botched personal jurisdiction apparently.
That's
But
right.
yeah, just check back with us and connect with Stephen on his Facebook page. And you guys have a great day, and we'll see you, whether that's next week or 3 weeks or whenever. It'll be soon. So
we'll see you soon enough. That's right.
Okay, guys, have a good one.
Bye-bye.